Okay, real talk. If someone brings up a prenuptial agreement when getting engaged, one of two things happens. Either it's the mature, responsible thing to do, or one of you immediately wonders if the other person is already planning their exit. I'm here to tell you, a prenup is not a plan for divorce. A prenup is a plan for clarity, and in North Carolina, it's one of the most powerful tools a couple can have going into a marriage. I'm Erica Benson. I'm an attorney here at Cape Fear Family Law, and this is everything you need to know about prenuptial agreements in this state. Myth number 1, prenups are only for rich people. That is false. If you own a business, have student loans, have assets from before the marriage, are expecting an inheritance, or if you just want clarity about how finances will be handled, a prenup is for you. The size of your bank account is not the qualifying factor. The desire for clarity is. Myth number 2, asking for a prenup means you don't trust your partner. I'd argue the opposite. A prenup requires both of you to sit down, to be honest about your financial reality, and have explicit conversations about your expectations going into this marriage. That is not distrust, that is communication. And it is way more romantic than arguing about who owns the beach house when you're both miserable and in a deposition. Myth number 3, prenups are one-sided. One person wins, one person loses. A valid prenup in North Carolina must be fair to both parties. It can't be used to waive child support, it can't be signed under duress, and if it was signed without the other party having reasonable time to review or without a full financial disclosure, it may not hold up in court. In North Carolina, a prenuptial agreement can address a lot of ground. You can define what stays as separate property, your premarital assets, your business, your inheritance, versus what becomes marital property subject to equitable distribution if the marriage ends. You can address alimony, specifically whether it will be paid, how much, and for how long. You can protect your business from being considered a marital asset. You can allocate premarital debt so that one party isn't inheriting the other student loans as a marital obligation. And one of the most practical things couples include, provisions about what happens to property during the marriage. Not just what happens at divorce, but who's responsible for what mortgage? What happens to the house if one of you dies? These are real conversations that real couples need to have, and a prenup is a structured, legally binding way to have them. This is important. There are things in a prenuptial agreement that you cannot do in North Carolina, and I want you to know them up front so there are no surprises. If a prenup cannot waive child support or predetermine child custody arrangements, North Carolina courts retain the authority to make those determinations based on the best interests of the child at the time. No contract signed before a child even exists can override that. Second, a prenup cannot include provisions that are illegal, unconscionable, or that essentially incentivize divorce. You cannot write a clause that says, if we get divorced, you get $1 million, because arguably that encourages the dissolution of the marriage, and courts just will not enforce that. Third, and this is the one that catches people off guard, a prenup may not be enforceable if it was signed too close to the wedding, if there wasn't a full financial disclosure, or if one party can demonstrate that they signed it under pressure. We're signing this the night before the ceremony is not the vibe. Get it done well in advance, with both parties having had time to review and ideally consult with their own attorneys. Let me tell you what you're working with if you don't have a prenup, because understanding North Carolina's default rules is the best argument for having one. North Carolina is an equitable distribution state. That does not mean 50-50. It means what is fair and equitable under the circumstances. Courts will look at how long you were married, what each person contributed financially and otherwise, the economic circumstances of each party, any dissipation of assets, that's legal for one spouse burned through the money on the affair, and a whole list of other factors. The outcome is not predictable. Here's a real scenario I see. Someone builds a business before they get married. They put everything into it before and during the marriage. And by the time the marriage ends, that business has grown significantly. Without a prenup clearly defining that business as separate property, the increase in value during the marriage may be considered a marital asset. And now they're negotiating about their lives' work in a settlement conference. A prenup could have addressed that in 4 sentences. If you're watching this because you just got engaged, congrats. Genuinely, and I know the last thing you want to do during engagement season is think about what happens if it doesn't work out. I get it. But here's my ask. Just have the conversation. Look at your financial situation, look at your partner's financial situation, talk about what you both expect, and then, if a prenup makes sense, come talk to us. We'll do it before the wedding. A well-drafted prenuptial agreement does not predict doom. It protects both of you. It removes financial ambiguity from your marriage, and in a strange way, it can actually bring you closer because it forces the conversation that most couples avoid until it's too late. At Cape Fear Family Law, we help couples in the Wilmington and Durham areas draft prenuptial agreements that are fair, clear, legally sound, and built to actually hold up in North Carolina courts. If you have questions, whether you're engaged and want to learn more, or if you already signed something and want to know if it's enforceable, reach out. The link for a consultation is in the description, and if you found this helpful, subscribe, because we make this kind of content every week. Thank you for being here.